Good morning. Very welcome to all of you. We all are assembled here to have a witness a special talk on the new laws. And today's speaker is none other than the additional Solicitor General of India for a state of Telangana, Shri Narasimha Sharma, sir. He is also additional in charge as additional Solicitor General for the state of Andhra Pradesh. Before starting presentation of the today, I would like to brief about the matters, subject matters on which we are going to present and hear from the sir. Now, before going to that, I will invite our distinguished speaker, sir, and being Administration and Finance, Professor Raghav sir, Registrar of the Institute, Sri Sumit Kumar sir, to come on the dais. We are very happy to see you, sir. So, as a subject matter of the today presentation, as we know, these new criminal laws were introduced in the House, in the Parliament, in August 2023. So these three bills intended that time to replace three criminal laws. Bharatiya Nyaya Sanhita bill was introduced to replace the Indian Penal Code, and Bharatiya Nagrik Suraksha Sanhita bill was introduced to replace Criminal Code of Justice, Criminal Procedure Code, sorry, Criminal Procedure Code, and Bharatiya Sakshya Sanhita Adhiniyam, Bharatiya Sakshya Adhiniyam bill was introduced to replace the Indian Evidence Act. By and large, when this bill was introduced, so purpose reason was given that these existing new laws on the tools are basically enacted during the British time, and main focus area is to safeguard the British administrations and bolster the British theme. And focus area is punishment. So that's why it was called Indian Penal Code. Now we have to shift the focus area from punishment to the delivery of justice. That's why name has been given Bharatiya Nyaya Sanhita. So various problem was raised during that time, and it was referred to the standing parliamentary committee. It was discussed at large, and at the end of the previous year, that means in month of December later period, it was again introduced and passed by the houses and got answer of honorable president, and it became law. And by the government notifications, it has come into the force from the first day of this month. That means 1st of July 2024. And we are here to have a good discussion, presentation. Some questionnaire will be taken by our honorable distinguished speaker. So before going about today's program, I will invite our Dean Administration and Finance, Professor KMSS Raghav Rao sir, to please come and say a few words, and after that we will start. Please, sir. Thank you, everybody.
Yeah, as Umesh said, there are really few words only because the subject area is far from our expertise. Whatever little I wanted to tell, some of them already Umesh has said. So, learned speaker of today's function, Shri Narasimha Sharma ji, Registrar IIT Tirupati, and my colleagues, students, very good morning to all of you. I welcome all of you for this important seminar or lecture, which we supposed to know. I appreciate the initiative of the institute, maybe at the directive of the government, to arrange this. As Umeshji said, these are three laws introduced or come into effect. They have come into effect to replace the IPC, CRPC, and IEC. So everybody agreed of the same opinion that these are very old, they have been in place for 70 years, they need replacement. But the difference came, opinion came only the way it is implemented or it has come to brought into law and what are the changes made. There are some difference of opinions which may be sorted out by mutual discussions. Disagreement does not mean that it is a healthy sign of intellectuality. So we should not feel concentrating only on the those aspects. Whatever important points I found these laws, I will bring anyway. We will be educated by our learned speaker. More importance was given for terrorism and anti-national activities. They are more focused, they are taken more seriously. Police have given more power, unlike before. The custody time has extended to longer period compared to earlier. So, speedy disposal of cases was another important thing. We are aware that thousands of cases are pending in the court. Only the influential clients who can afford to engage influential lawyers like bigwigs who can influence the judges to get the hearing, their cases are disposed very quickly. Common man will have to wait years and years. That's why there is a normal saying, justice delayed is justice denied. So that is the plight of the situation. That situation has apparently improved in the new scenario. In some cases, community service is introduced as a alternate punishment. That was a very welcoming move. If you remember, I do not know, there are many movies have come on this as is, suggesting that community service as a punishment for the crimes to reform the person rather than to punish the person. So similar thing has come. Now FIR can be lodged in any police station irrespective of the jurisdiction. That was a very, very convenient thing for many of the common man. Trial in absentia is permissible. Getting bail is rather more difficult now. Of course, we have to see the flip side of all these modifications and arrangements. New terminology is, it will really take time for everybody to get hold of it. Not only for lawyers, of course, far away from our common man. Any rules or laws, they do not have teeth by themselves. How they are interpreted, how they are implemented, that's where their impact will come. So, to what extent justice will be delivered. We all agree that, as Umeshji also mentioned, it is more important the delivery of justice rather than pronouncing the punishment and pronouncing the sentence and implementation of the punishment is affected. Early laws were there for 70 years. So at least let us give few years, at least 5 years, how the new laws will be impacted, their pros and cons we will come to know. Time will tell us. So the expert speaker will educate now. Before taking much time, I will leave the stage for him. I thank the organizers for this opportunity. Jai Andhra, Jai Bharat.
So now this is time about the land speaker, sir. Sir, in 1959, the state of Andhra Pradesh, that time it was not divided state, and Shri Sharma, sir, graduates, student in science, and completed in Osman University. This, sir, you have been involved in the Bar Council of Andhra Pradesh in 1982, and it is really a great pleasure for me to say something about you. That time I was just a 3-year-old kid playing in the ground with the mud. That time we were practicing, sir. Really, sir. And after enrolling as an advocate and being the constitutional law expert persons, you have served in cases and council and committee and particularly government like organizations. I would like to mention here appointed as a senior counsel for central government, becoming as an additional Solicitor General of India for the High Court of Telangana. He is also member and still member in the Senior Assistant Counsel for the Income Tax Department, Central Tax Customs, and Directorate of Revenue Intelligence, the Directorate of General GST Intelligence, and Enforcement Directorate. He is also a standing counsel as a senior standing counsel for the Narcotic Control Bureau, and now you are also appointed as senior advocate in the High Court of Andhra Pradesh. He is also nodal counsel for the Union Public Service Commission and a standing counsel for Controller and Auditor General of India, Bharat Sanchar Nigam Limited, Kendriya Vidyalaya Sangathan, and other central government organizations. Sir, he has been appointed as Additional Solicitor General of India for the High Court of Telangana State in Hyderabad on 17 October 2023. And in the month of November, 15 November 2023, also he signed additional charge as an additional Solicitor General of India for High Court of Andhra Pradesh at Amravati. He will practice High Court of Andhra Pradesh for more than 40 years, and it is really a great pleasure to listen and share. It is also our great to share this experience also in addition to the new laws that will also benefit us and it will benefit all of us at large. So now I will request to hear your sir. It is really and it right and better schedule you given time for us. Sir, thank you, sir.
No, no, not yes, that. Regarding sir, like awesome. No, not comfortable. It's more comfort because we are habituated by making submission standing in court. So I feel that way same way. అందరికీ శుభోదయం, నమస్కారం. Let me start first offering all our pranams to Lord Venkateshwara in this city of temples. I offer my humble pranams to each of the distinguished director, sir, particularly Satyanarayana sir, Professor Raghavarao garu, Sumit ji, and Umesh ji. My dear friends, sisters and brothers, I know you all are not from the legal profession. The subject is from the new criminal law. So I am not going to address like any gathering of legal practitioners, but it will be an address or sharing my views with the common public with a common understanding. Before coming to new criminal laws, the topic which was given to me, really I feel honored to be here by stepping into the one of the premier institute, that is IIT Tirupati. It will be dream of every student or child in this country to enter IIT by studying, then by research, then so many positions. And their career, they want to show that we are from IIT. You are all, I congratulate each one of the here students who are here. You are all having that distinction. But the person who is sharing the views with me doesn't have that background. But I feel honored to be amongst all of you today. Dear friends, this new criminal law, before going to that, to make it a simple bird view of the subject, suffice to note that this is called generally in the present time administration of justice. This is the system. Let me briefly mention how this administration of justice was there from ancient times in our great nation, that is Bharatavarsha. From the beginning, the administration of justice was with two classification. Administration of justice for the civil rights, which includes personal property, etc., etc. The second one is the criminal justice system. This criminal justice system, it was earlier the duty of the king who was ruling his particular territory. It was treated as a sacred state duty. In those days, it was called as a Rajadharma. And the king has to, it is being part of that sacred duty of Rajadharma. The king his duty is to detect these sinners. Those days, now we are calling as offenders. How, just kindly appreciate how the society has treated an offender at that time is sinners. It was the duty of the king at that time to detect the sinners, punish them with due process of law, and objective of this punishment is criminal law is twofold. One is to punish the sinner or offender. The second one is very important, is imposition of penalty or punishment on the offender will regulate the conduct of the people in this country. It protects the society. Imposition of punishment protects the society. Let me mention a classic quotation. Dandashasti prajas sarva, dando rakshati, danda evavi rakshati. So this is the twofold objective of imposition of punishment. Imposing the punishment, by virtue of imposition of punishment, people will regulate their conduct not to commit such offense because they are afraid such a severe punishment will be levied on them. And it also protects the society. And it was also mentioned that the imposition of punishment should be with impartiality. At that time also, establishment of protection by now what we call police there used to be that unit of protecting officials, that is police station, at village, 10 villages, 20 villages, 100 villages. And what these police people has to do, they have to detect the offenders, bring into the process of administration of justice before the king, get them punishment. And it is always sacred duty of this thing, and corruption and offences of corruption was taken very seriously. One of the scripts says that corrupt officials shall be liable for expulsion from the country. Corrupted public officials shall be expunged from the country. That was the serious object that was taken. And whole object of this criminal law was, if it is properly implemented, people in the society will live with peace and happiness. This was the great legacy of our country in the criminal justice system. As you all know, friends, during British rule, it is to just mention, not to bother you, there was a first Law Commission of India in 1848 by T.B. Macaulay. He recommended for regulation of, because they want to rule this country, so they want a law to punish us. So they copied Irish Penal Code and imposed on us as Indian Penal Code. This law came in 1860. And as I mentioned, there should be due process for punishment of the offenders. For that purpose, Criminal Procedure Code of 1872 has been brought into. That was replaced by 1973. And finding out the truth is the main element in the due process. Really, he is the person who committed the offense. That is called in those days Satyanveshana. So for that purpose, there should be evidence. So the basis also to the law relating to evidence, that has also been brought from the colonial laws, and it was made as an Indian Evidence Act for us. Dear friends, there was also, this was the experience prior to 150 years in this country. It was a law made by foreign rulers to impose Indians. If a British or somebody commits an offense, there is no law. Only to punish us here in this country, this law was made. This was continued for more than 150 years in this country. After so many 70 years or so, after the independence also. Various law commissions, which are an expert body on the subject, there was series of recommendations to re-look into various offences or the words crown. So many words which have no relevancy to our society are frequently used in those laws. Neither it can be understood by common man nor the persons of the police or court or the judges. Such type of words were continued in that laws. So there was series of recommendation by the law commissions to re-look into various provisions of these three laws. And there was also a series of recommendations by the Standing Committee of Home Affairs, which deals with the justice system, also to re-look into so. Kindly also note that there was series of judgments of the Supreme Court saying that certain laws are constitutionally not valid, certain laws for certain offences there is no provision under the existing laws. These are the compelling circumstances which resulted to an exercise to commence for re-look into the existing laws, and the process started in the year 2019. And it is a fact on record that in collaboration between the Ministry of Home Affairs and the Ministry of Law and Justice, with various stakeholders, more than 58 formal meetings and more than 108 informal meetings with so many experts and stakeholders were taken. And the draft laws were circulated to states, all stakeholders. About 16 states have shared their inputs also for this draft laws. 6 law academies, more than 150 members of parliament, about 260 or something from the legislators, Chief Justice of India, Chief Justice of various high courts, so many law schools. All these inputs were taken into consideration for drafting. One of the option was whether we can go for amendment of the existing laws. But the challenges are so multiple. So it was very rightly decided to replace those laws. Just dear friends, please note that earlier laws is Indian Penal Code to punish it. And the title itself is only object is to punish. Now, Bharatiya Nyaya Samhita, it is to do the justice, not mere punishment. It is to render the justice is the main objective by title and content. Sanhita is nothing but code, codification of the existing principles. Similarly, the procedure due process of law in the field of criminal administration of justice, criminal justice system, criminal procedure code, instead of calling them as a criminal even before they are convicted, now kindly note that the present name is Bharatiya Nagarika Suraksha Sanhita. And third one is evidence is, as you know, which is the local for us, Sakshya Atiniyam. So please note that as rightly used the title as well as the content, it is with the Indian concept and in the complaints of our approach to this criminal justice system. And as Sir has mentioned, these three laws came into force from 1/7/2024. Let me just briefly mention what are the silent features that were brought under the Bharatiya Nyaya Sanhita, that is BNS. Instead of using the word IPC, we will be using BNS. No confusion. Lot of misinformation and other things are going on in press. It is not that it is just hurriedly brought or something. As I mentioned, it was an exercise for last 5 years, duly involving various stakeholders and taking note of so many inputs that were received. And major issue was in the earlier laws, as they were drafted by the colonial rulers, definition of the concepts itself took about 52 sections. Now it was systematized only by one provision, making it simple. And under criminal law, there used to be 5 punishments. First is imposition of death penalty. Next is the imprisonment for life. The third one is imprisonment simple or rigorous. Fourth one is imposition of fine. Fifth one was the forfeiture of property stolen or caused loss. These were only the standard 5 punishments that were there recognized in law. Now, we require that by way of imposition of punishment, because the way many object of this great ancient jurisprudence in this country is also to regulate the conduct and to bring the reforms. That is the reason, as Professor Raghavarao has mentioned, a reformative punishment, the concept of community service has been brought into now. It is for certain types of petty offences. Instead of sending him to jail or imposing the fine or the traditional 5 punishments, he will be levied with the community service without any remuneration. The objective is, during that period of community service, he is now exposed to the society. Irrespective of his background and distinction, he is doing certain type something as a punishment. That is a humiliation before the other members in the society. So that objective is also to bring reform to himself, but not to repeat that type of offences. Second one is, those who are seeing his community service punishment, if we commit this type of offences, tomorrow we will be also liable for this. So it will also regulate the conduct of the other members of the society. This is a very innovative, salutary principle that has been brought into for the first time in our criminal system as a community service, one of the punishment. And very, very important is, last 2 decades, there is alarming increase of the offences against women and child. Certain things, if we come to the offences against women, it may relate to sexual issues, it may relate to marriage, it may relate to use of criminal force or assault on women, or it may relate to any offence against her body, causing miscarriage, inducing by false promises to marry or for employment, other things. There was no provision in the existing Indian Penal Code to effectively prosecute such type of serious offenders. Now, I will mention that a salutary exercise has been taken now to give precedence for these offences against women and child. Under earlier law, insofar as the offences against child are concerned, there was a lot of variation and confusion between the 12 years to 18 years. Either the case of accused persons or the victim. Now uniformity has been brought. Instead of using the word minor, which created a lot of problem earlier, that word has been replaced by child, and all the persons below 18 years were brought for the same uniform system of these offences. And very, very importantly, in addition to this, because considering the time constraint, I am just making it a brief note. Certain offences, instead of doing individually, it became difficult to control. Organized groups are involved in such type of heinous offences. And that is the reason, and the earlier offences which were contemplated by the earlier law were inadequate to bring those erring persons to the system of criminal justice system. So this mob lynching on the ground of race, religion, sex, locality, all other cases, that was made a serious offence now. Dear friends, you must have read for last 5 years or 10 years, there was a lot of criticism on the misuse or use of sedition laws, sedition offence. Sedition was made an offence, as I mentioned, by Britishers to punish the persons who incites or do something disaffection to the government. Some people are saying that it's a Rajadrohi. Now that has been replaced by the very thing is those who commit that type of offence, endangering the sovereignty, unity and integrity of the country. So sedition has been replaced by treason now, and really needed concept has been included to that. And I was mentioning that group of gang offences. This they were called as organized offences. To make it simple for you, because you are not from the legal fraternity, this is a continuing unlawful activity. Nothing but organized crime is continuing unlawful activity by so and so persons committing for so and so, for the either for the benefit of money or otherwise, acting in concert. So there was no law which was applicable to the entire country to control those organized offences. You may recollect that the threat of that organized crimes from the underworld group people was there in Maharashtra, Dawood case and other cases, which resulted for making laws by respective states. That was the starting point for the organized offences. Maharashtra Control of Organized Offences 1999. About 13 states copied it. They have their own rules. The procedure there was very cumbersome. Special court, only particular officer, only one court for the entire state. So increase of such offences are alarming, but the system is very, very limited. It became inadequate. So there was, that offence has been brought to the regular criminal justice system, administration of justice system, by making it a serious offence under the IPC. It has its own definitions. I am not going to the details now. So in a uniform penal law, by making the organized offence as one of the major offence, is an addition to the Bharatiya Nyaya Samhita, BNS. Terrorist activities, there was a law, generally as you know, banned organizations that will be under the Unlawful Activities Prevention Act 1969. There, by use of deadly weapons like bombs, ammunition and other things, if you commit a terrorist activity, either to cause a death or to cause property or to disturb the services, so many things are there. But that procedure was also very cumbersome. There, if such an offence is committed, for example, in Vijayanagaram or somewhere remote area, the police officer cannot do on that offence immediately. He has to send a report to the state government. State government has to send a report to the Ministry of Home Affairs. Then they have to decide whether this matter requires to be taken by the special investigation. They have to give a notification. Generally, you will be reading, coming across the word of NIA, National Investigating Agency, enters that case, bring the procedure before a special court, which may be only one court for the entire state. So that was also found to be that such type of serious offences with the more stringent punishment has to be brought. This is a new provision brought to BNS by adding this terrorist acts. Now it has been, now the officer, of course not below the rank of superintendent of police at the district level, if he receives the information about the commission of terrorist act, he will decide whether it should be proceeded under the regular law or it requires to be proceeded under the special law. Based on his decision, it will be decided. There is no confusion, there is no contradiction with the special laws. Friends, you also know in recent time, commission of offence in India is very seriously abated in foreign countries. Abatement means planning, support, everything in different ways. There was no provision under the IPC or our CRPC, and there was also decisions of the Supreme Court. This area has been not looked into. Serious offenders who are abetting the offences for commission in India are being let out. It is endangering to the very integrity of our country. So that provision of bringing that abatement outside India for the commission of offences in India has been made a serious offence now. Further, many times, particularly the person, real culprit, is absconding, charge sheets are being filed in absentia, years together, decades together, cases are prolonged for want of his presence. Unless he comes and joins, entire trial cannot go. It was also observed many times that there should be split of cases, then it will be another difficulty. So many legal consequences are there. For that reason, now in absentia trial is also legally permitted now. And as I mentioned, offences against the state are concerned. And this mob lynching has been brought on par with the murder now. And particularly inducement of women by false promises or committing other sexual offences by such things. That has been given high precedence in this with the severe conditions. And as you know, there is very a great scale of increase of offence of snatching. Sometimes it may not result in theft, but snatching offences are being committed. That was not covered by the IPC. Now snatching is also made offence now. And when it comes to other areas, in addition to terrorist activity and other things, using of electronic devices and technology, either for abatement or commission, that was also not covered area in the existing laws. That has been brought into now. Because these are all very day-to-day changing concepts. Present information technology and other offences are inadequate to deal with them. This gang rape or other activities, they were brought with severe punishment and stringent conditions now. Hiring of children to commit the offence, importation of children for commit the offences here, that has been made a stringent offence now. Dear friends, every day we are seeing death of the persons in road accidents, hit and run. Earlier, negligent driving was inadequate to bring them into that this thing. As per the statistics, more than 60%, 66% of road accidents are fatal. They are resulting in death, particularly after development of our four-ways and other things. So that hit and run cases were given precedence with a suitable severe punishment now. You must have also read that there was also agitation against this. Hit and run cases are concerned if the offender who commits that death or other offense by that, if he informs the police, if he takes the victim also to the police hospital for treatment, then punishment is lesser than the person who flees from the scene of offense. And certain offenses resulting in permanent disability or persistent vegetation, that also made a serious punishment now. Economic offenses are alarming. That has been brought, this like either mass market frauds, hawala transactions, or defrauding the public with false schemes and other things. This was brought under that organized and other offenses, serious offenses now. Dear friends, like this, waging a war against the state also has been given a serious look and precedence now. The offenses against the public servant, by and large, a serious effort has been made. There may be some other thing I want to mention. Adultery, which was declared as illegal earlier by the Supreme Court, now that has been deleted now. In nutshell, considering the topic for this, very new challenging offenses which are coming every day in the society, provision legalized, the offenses are certain areas which were not earlier covered, has been brought under the BNS now. Coming to the second part, that is Bharatiya Nagarika Suraksha Samhita. It is also intended to give sufficient protection to the common man. Earlier, as mentioned, penal laws were to punish the accused. That was accused-centric laws. Now, by this relook and redrafting, the present laws are victim-oriented, society-oriented. The reason is three ways. Earlier, victim was a silent spectator, just giving the information whenever they are called to the court, find out, because then neither they can conduct their case or they can participate, nor they are entitled for any information, nor they are entitled for any documents. And even cases which are withdrawn by the state or somebody, they have no role, now they are the victim person. Now the present law, please note this. First stage is, as Raghav sir mentioned, zero FIR. Anywhere in the country you can make an application. Police is under obligation to register it and send it to the persons. You need not go to the police station also. You can register that EFIR. They have duty to come and take your signature within 3 days. That is a different thing. So the first step is making victim oriented, is enabling the victim to commit to make that information from this GUDO FIR and EFIR. The second stage is victim is entitled to police is liable to, it is under a duty to inform the victim about the stages of progress of the investigation. The third thing is, victim and the society is also entitled for free copy of the FIR. They are given the statutory entitlement to have the documents which were relied by the prosecution. And now the victim is also entitled. Very important is, many times cases will be closed by the prosecution. Now it is a duty of the court and the prosecutors that before withdrawing any criminal case already launched, notice has to be given to the victim and victim has to be heard. I just forgot to mention, earlier laws were dealing only with men and women. You know, as per the present statistics, more than 6 lakhs is the transgender population in this country. The rights of transgender has been recognized by the Supreme Court. There was no law on that issue. Now, certain offences are under the IPC and the procedure therein, they were made gender neutral now. So, at the stage, from the stage of FIR, investigation, registration of the case, supply of documents, and right to assist the prosecution by the victim, finally, an entitlement of hearing before closure of the case which was filed by them. These 5-6 areas, victim has been for the first time were given the statutory rights, and every stage new criminal procedure code, new criminal procedure code, under 8 minutes said that. It has prescribed the time limit for everything, and police shall comply. Not only that, time limit is for even the court proceedings also. Number of adjournments, it can't go for more than 2. Time frame for framing of the charges, time frame for examination of the people, time frame for pronouncement of judgment. So the very object of inculcating this timeline concept, every stages of this procedure is intended to ensure the speedy justice. And as you know, earlier Evidence Act only by documents and oral evidence, and most of the witnesses turns hostile, and there will not be documentary evidence insofar as commission of the offences mostly. Now, by evolving day-to-day changes in the digital devices, electronic communications, electronic techniques, this use of this electronic communication as a document has been brought under the statute. Documents include electronic documents, digital records, everything. And particularly in the offences against women, in case of rape and other cases, this forensic evidence was there. Now for the first time, maybe in the globe itself, forensic medicine, forensic examination has made part of the criminal administration of justice. Because the areas I am not going, for certain offences above 7 years, the video recording of the site, that has been mandatory now. Every stage there is checks and balances in the new law now. There may be few areas which may also require further improvement, because for the first time total law has been replaced. As I said, existing state laws by each state were inadequate to deal with the increasing the organized offences. That is the reason uniform law has been brought. In the same line, required changes can be worked out by necessary amendments and further improvements. Particularly this rights to the victim that has been as a part of the system now, and the timeline at every stage, accountability of the police, powers are given, but powers without any restriction was there now. Everywhere, arrest information shall be maintained. For example, I am not going to the details. Arrest information shall be maintained in every police station for the arrest made there. A particular police officer shall be made responsible to update that proceedings, information. Track record of the offences committed by the offender shall also be maintained. And if it is repeated commission of the offences, 2 times, 3 times penalty has been levied now. Series of changes has been brought. Particularly, even the offences of endangering the monetary stability of this country has been brought under the BNS and BNSS. And counterfeiting offences and related offences are made more stringent now. By having the glance to the changes that has been brought, I must mention that these are the laws with indigenous thinking, indigenous concepts, and it has been made more simple and technologically supported system of investigation and proceedings. And it is solemn duty of every stakeholder, that is the public, investigators, lawyers, courts, to take up this challenge and work for the main object of concept of ease of justice. And insofar as Sakshya Adhiniyam is only 2 minutes, sir. Sakshya Adhiniyam is concerned, not major changes. Major changes are in the Criminal Procedure Code. Insofar as BNS is concerned, that 511 offences to sections 2, it has brought down to 368 or something. But when it comes to Criminal Procedure Code, because of the so many changes inculcating this electronic and other devices, forensic medicine, forensic examination, medical examination of the victim shall be done by the women officers. Only in exceptional cases, it is by the regular doctors. And report also has to be sent within the so and so period, furnishing the copy to victim. This is a area only introductory sharing of views to you. Even for example, in organized offense, it requires one total session, 1 day. Terrorist offenses requires 1 day, 1 session. Mob lynching, gang rape, offenses of against a state, these are all serious offenses. Suffice to say that major changes has been brought to the procedure. Offences which were not covered, and the offences against, as I mentioned, against the transgender and other things, they were brought for the first time now. As mentioned, really it's a progressive path in administration of criminal justice. Let us all welcome this challenge, work with the system, and be part of this system to ensure that speedy justice system is achieved with more simple, with the due process of law, participation of all stakeholders, with a timely and procedure, and effective control of these things. I am once again grateful for the, particularly this Chaman Mehtaji, who was behind me for last 10 days. Sir, you come any working day. I'm sorry, because of my predicament somewhere, I could not make it last week. I once again thank our revered Guruji Shri Raghav Garu, Viswasji, and each one of the distinguished members here. Sir, today, by your affectionate command to me to come here, my dream to enter IIT has been fulfilled today. Of course, I could not come as a student. I didn't have that merit to come here. I could not venture any other way to come here. When I met, really, I have all the words of appreciation to our director Ji, Satyanarayana Garu, that this great premier institute, one of the premier institute, got about 20 distinguished appreciations at the national level in different fields. Though it is only 10-year born now, I think December 2015, 9 years or so. Let us hope and wish with the distinguished faculty members, most serious students, this premier institution will flourish. We'll look forward some other occasion. And I once again thanks each one of you for the patient hearing given to me. Great of you, sir. Sir. Wow.
Thank you, sir. And you are so simple, and that reflect your genuineness and humble. Because you are saying I came here not as a student. So simply you are saying your thing, but it is our good fortune you are having with us, learned person like you, sir. And we will also request sometimes when we are calling, please come. Yeah. So now this is time. We will. I will request Ravara sir to hand over the small token of love and register sir. सर पेंटिंग से लिखवा दीजिए इसको. Now I will request our registrar sir, Sri Sumit Kumar Biswas sir, to come on the base and say about the
Morning, all of you. Uh, First, I want to give a big thank you, sir, Mr. Mr. B. Narasimha Sharma ji is the additional Solicitor General of High Court of Telangana. But besides that, he is also the additional Solicitor General of High Court of Andhra Pradesh. He's a very busy person. Actually, Chairman was trying for the last few days, and every day he is behind him, sir. Give me some time, and if it's possible, in working days. And yesterday, sir was, I mean, day before yesterday, sir was in Delhi with the Ministry of Law. There is a meeting, and he came back in the yesterday night, and then in the morning he came back here. So it's a nice thing, sir. You have come over here, and this because this area is very new to us, all of us, because for the the colonial laws or criminal laws were for the very long period it has started, and we are not change anything. There are a big gap because of the societal shifting. Due to societal shifting, also we have advancement of technologies, but these are there is a big gap. So these are very much required. This kind of changes were required, but we are practice. We have the habituated with the previous laws, the IPC, CRPC, and Evidence Act. And so whenever overall new laws will come, it is a very difficult to understand, very difficult to know everything. Sir, you have given us a clear-cut idea, very simple way. We are not legal fraternity. So in the morning also when he discussed with us, also he told that I will not give my talkings or lectures like that way, that we are in front of legal fraternities, because we are not, we are very common person. We are dealing with the administration. For dealing with the administrations, we should know about these legal views. But since we are not the legal personnel, it is very difficult for us to understand all this. Legal words are very much difficult to understand. But he has given us a very good idea, very simple way. He told us what are the changes. He started with a background history, how this IPC, CRPC have come. Then he told us what the changes have been made, why it is necessary. So it's giving a very good idea among us. And we have, this is just started in 1st of July. Times will say how good it is, where is the lapses. Then we learn to know there may be some changes if required. So it will a long time to go, and we'll learn a lot of from them. But still, at the beginning, you have given us a very good idea about these changes. So thank you, sir. And we also hope in future, if this kind of occasions occur, we'll invite you, and so that you can come over here and give us some more ideas about different parts of aspects of this law that is also required. But let's give some time so that you can understand, and later on we can ask you again to come over here. Thank you, sir. Thank you. Thank you all of you to join over here and listen to this special talk. It is very much necessary. And the government has in India has introduced a new laws. The government is also trying to create awareness among all the citizens. And as a part of citizens, we have heard something from him. It's a very good opportunity for us. So thank you all of us.